You're watching Capital Connection from the Illinois State Capitol.
Welcome back. Last month, the Illinois Supreme Court issued a pivotal and long-awaited ruling on the Biometric Information Privacy Act, a long-standing law here in Illinois, one that sets the state's standards for online biometric privacy at a level that's not seen anywhere else in the state. Now, this Supreme Court ruling makes that law even stronger, and it's making a lot of business groups across the state very nervous. Joining us now is a representative from one of those business groups, Mark Denzler from the Illinois Manufacturers Association. Thank you so much for joining us.
Thanks for having me, Cole.
Let's start here. This week, you were joined by all sorts of different business groups. We had healthcare, we had Truckers Association, we had just everybody, the entire spectrum here, talking about why this is such a big deal. And why is it such a big deal? Could this be so harmful for businesses?
Well, the Biometric Information Privacy Act was first passed in 2008 in Illinois, and there were no lawsuits for about the first 10 years, and then there was a decision against Six Flags that ruled you don't even have to have any harm to be able to recover damages. And in the last 3 or 4 years, Cole, we've had 2,000 lawsuits filed in Illinois. In the case you referred to, the White Castle case, the potential award could be $17 billion. And in their case, it had to do with using fingerprints or thumbprints for a time clock. And so the two court cases have really created havoc in the state of Illinois. We're the only state in the country with a law like this. But the two court cases in February, number one said there's a 5-year statute of limitations instead of a 1 year, so longer cases. But more importantly, in the White Castle case, every single time that you collect fingerprints, for example, that is a separate violation of law. So you think about a manufacturing worker or a restaurant worker or a hospital worker, they clock in for work, they clock out for lunch, they come back in the day. That's 4 different violations, each one punishable up to $5,000. That could be a $20,000 fine per day per employee. And so the trial lawyers have really hijacked this and really created significant hardships and made Illinois an outlier.
So the Biometric Information Privacy Act, or BIPA as it's commonly referred to, like you said, it's been law for quite a while now. And it's as, businesses across the state have begun to use more and more technology, that has been the law. I wonder, why is it so difficult to comply with this? If it's just, and make sure the people know all of the information about when they're giving this sort of information, like a thumbprint or maybe a face scan or something like that, why is it so difficult to make sure they're aware of what this could be used for?
Well, that's a great question. And first, I would say when the law was passed in 2008, we didn't have the technology we have today. And so the law has not kept up with technology. But as we heard earlier today from the Hospital Association, every time a doctor or a nurse wants to go in and get prescription medication, for example, they have to submit their thumbprint because they have to keep track of who's dispensing the drugs. They have to get permission every single time. It's not what we know as the evergreen standard. When you think of HIPAA, you give your permission one time and then you're good. In this case, you have to give it every single time. So think of that doctor or nurse. Maybe they're getting medicine 8 or 10 times an hour. The time that they have to sign off and say, I give permission. But this is so important for security. When you think about an employer now has a legal obligation to protect someone from domestic violence if there's an order of protection, and you think of a large retail store that has security cameras, if they can use that to identify that potential attacker who may have the order of protection against them, and that person enters the store, they can notify security to make sure there's no incident. And so it's important from a safety and security point of view. It's important for manufacturers that might have intellectual property. You think of a large pharmaceutical company where they restrict access to where their highly valued classified information is. You have to protect that data. And so it's not as simple as saying, hey, just sign this paperwork and fine. The court decisions have ruled separately that each violation is offense. So you have to get permission every single time.
This has been a push from business groups for a while now to sort of loosen the parameters of this law and make it not as punishing for businesses, but this latest ruling seems to really have accelerated that process. We even had bills filed in this session before the Supreme Court's ruling came down. What's the solution? Where do you go, and what are the asks that you and the other groups have?
Well, and it's a good point. We've been pushing for changes in the BIPA law for years. We've had legislation, the IMA's introduced legislation for a number of years. We're part of this coalition, as you talked about, with the retailers and with the hospitals and nursing homes and truck drivers. And the first thing I would say is we're extremely concerned about privacy. We don't take this lightly. When you talk about these cases, you don't have to have any harm. There's not a single case to my knowledge where someone's biometric information has actually been lost or been jeopardized. So number one, the fact that you have to show harm to get damages. Again, so far there's been no harm. Number two, allowing biometric thumbprints for time clocks. Most people don't realize when you collect a thumbprint, they're not actually collecting your thumbprint. That is being digitized into a random sequence of about 20 characters. You have to have a code to unlock that. So even in the event of a breach, I'm not getting your thumbprint, Cole. I'm getting a random series of numbers and digits, 20, that someone would have to unlock. So I think people take a rather simplistic view of this, but this technology is so important. The nursing homes talked about how they have to report to the feds the amount of time by second that they take care of a patient on the floor. They do it by biometric information. And so in today's society, we have to use the technology. But that's nothing to be said. We can protect a patient or a customer or a consumer. We can protect their technology without foisting millions or billions of dollars in penalties on business. And one final thing I would say, we had a company that was testing automated vehicle technology in Illinois. And as that technology goes down the road, it identifies here's a person or an animal or a tree. They collect that, they then go back and they verify, did the technology do what it was supposed to do? They now have pulled out of Illinois because of the BIPA ruling that we saw a week ago. So we're losing economic development, we're losing technology. We should be a leader in that.
This is a really interesting discussion, policy debate here, because we're not working with a new law altogether. We're working with modifying an existing law, and one that sets these standards very high. Going forward, it's not like you can do all of these little cutouts for a bill. We have seen that before in certain laws where there are these exceptions that are put into the law, but just hearing from earlier this week when all of these business groups came, everyone had these small little, situations that they're like, that they say could punish them greatly, and they're all so different in the way that they work. We heard the Truckers Association talking about looking back at the video of their drivers and using that to improve how they work, and that could be used in these cases as well. How do you craft a law like this that centers around very serious issues of data privacy, but also make sure that all of these other businesses are considered in this debate?
Well, the language we have, and the IMA's introduced a bill with our coalition partners that take care of these, and that everyone's agreed upon. So things like using biometric information for time clocks, for example, that's something they all agree on. Using security cameras. So whether it's the truckers use it one way, or a retail store uses it to stop organized retail theft, or you use it to identify someone that may be an attacker that has an order of protection against them, that's the use of a camera. The most two recent court rulings, number one, making sure the statute of limitations is 1 year, not 5 years as the court ruled, and making sure when you collect the fingerprint, for example, the first time, that's a single violation. Not every single time you check in. Those are all very similar. Those are all ideas we share. It's called the evergreen, kind of similar to HIPAA. You attest one time that your privacy. We should do that instead of every single time. So all these ideas, while every industry has concerns about this, the fixes that we have in our legislation are applicable to all these sectors.
I think that, or with the Supreme Court ruling in particular, it was taken as this sort of really strict reading of the law, and this is what the law actually says. From your position, knowing when the law was initially passed and the discussions around it then, were all of these consequences unintended? Was this not the way that the law was initially supposed to work, but now it has to work this way?
I think there are unintended consequences. As I said, 15 years ago, the technology didn't exist that we have today. Think about what phone you used then. You didn't use an app to order your food online. You called the number at the store. And so the technology has moved forward. The law has not moved forward. And so, again, we can protect a person's privacy without penalizing the employer. I guarantee you, Cole, that in 2008, 15 years ago, nobody thought that White Castle would have to pay a penalty potentially of $17 billion that would put them out of the business if that ultimately is upheld. Nobody envisioned this law being billions of dollars in penalty. I can attest to that.
I wonder, with just all of this discussion, Illinois remains a front runner, a sort of a trendsetter in this field. There are states that still don't even have these kinds of biometric privacy laws. And I think a lot of people would see that and say that's a good thing, that Illinois is, leading the charge on these kinds of laws, but is there an opportunity, you think, to still remain in that position as as a state that is leading the way while also modifying it and making it so it is, not, so damaging to businesses?
Well, I don't think we're a trendsetter and leading the way in a good direction. I think what's happened is every other state has seen what Illinois has done and said, we're not going to do it. We heard about that earlier today. There's been a number of states that have looked at doing this. They've seen what's happened in Illinois and said, no, we don't want to do it. So we're not leading the way in a good way. We're leading the way in a bad way. We're discouraging economic development. We're discouraging investment in technology. As they talked about this automated vehicle company, they're no longer in Illinois. So what we need to do is reform this law to meet current technology, but there's a reason that other states haven't adopted this. There's 2 other states that have a much smaller, limited view of this. There's a reason they haven't, because Illinois' law is not working.
Well, Mark Denzler with the Illinois Manufacturers Association, thank you so much for joining us.
Thanks, Cole.
We'll be right back.